Good morning. This is Chair French convening the regular business meeting of the Kansas Corporation Commission for this Tuesday, September 24th, joined by my colleagues, Commissioner Keene and Commissioner Keither. On today's agenda, we have 9 consent agenda items and 3 noticed items. We will begin with our consent agenda. Commissioners, you've had the opportunity to review the consent agenda. At this time, are there any questions on those 9 items, beginning with Commissioner Keither?
No questions, thank you.
And Commissioner Keene.
No questions for me either. I'd move approval of the consent agenda.
Second.
All right, we've got a motion and a second to approve the consent agenda. Is there any further discussion on that motion? Hearing none, all in favor, please vote aye.
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 Aye. Any opposed, say no. The consent agenda is approved. We now move to our 3 noticed items. Our first noticed item is in docket number 14 ANGG 119 COM, and this is a proposed order on Kansas Farm Bureau's petition to intervene. Our presenter for this item is Mr. Brian Fedun. Good morning, Brian.
Good morning, Commissioners. This docket dates back to August 27th, 2013, when the Swickies filed a complaint alleging that they overpaid for natural gas from Anadarko off the Hugoton residue delivery system. And this docket's been to the Court of Appeals twice already and is back on our plate. So that's a little background. So on September 6, 2024, Kansas Farm Bureau filed an entry of appearance and a petition to intervene, claiming its interests and those of its irrigator members is or may be inadequately represented. Farm Bureau advises it seeks to file a brief in support of the Commission's applying the filed rate doctrine in this docket. On September 16th, Anadarko filed its opposition, noting that the sole basis to intervene is to represent irrigators and claiming that their representation may be inadequate. Anadarko explains the Swickies have been represented continuously by counsel since 2013, and that because more than 20 briefs have been filed over the course of the docket, there's no need for additional briefing. This order finds that the petition to intervene fails to demonstrate that Farm Bureau qualifies as an intervener under any provisions of law. This docket is a complaint alleging that the Swickies overpaid for natural gas and are entitled to a refund. The Court of Appeals has charged the Commission with determining whether the 2 gas service agreements between the Swickies and Anadarko were unreasonable, unfair, or unjust. That determination is fact-specific to the 2 gas service agreements at issue and should not affect the rights of other irrigators that rely on natural gas. Similarly, Farm Bureau provides no support for its claim that the representation of its interests by existing parties may be inadequate. This order also finds the existing record is more than sufficient to allow the Commission to determine whether the 2 gas service agreements between the Swickies and Anadarko were unreasonable, unfair, or unjust, and that there's no need for additional briefing. So for all these reasons, this order would deny Farm Bureau's petition to intervene. With that, I'm available for questions.
All right, thank you, Brian. Are there any questions on this item, beginning with Commissioner Keither
No, thank you.
and Commissioner Keene?
None for me either. I would move approval of the order.
All right, we've got a motion and a second to approve the order as described in this docket. Is there any further discussion on that motion? I will just note during discussion, I am recused in this docket, and so I will be abstaining on the vote. But with that, if there's no further discussion, all in favor, please vote aye.
Aye.
Any opposed, say no. And I am abstaining. With that, the order is approved. Thank you, Brian.
Thank you. Chair French, just for clarification, the order has you listed as recusing rather than abstaining. Do you want us to change that, or does that, I mean, it's semantics to me, but.
Yeah, I'm recused, so I abstain on the vote.
Okay.
So I did not vote.
Sure. I just want to be sure it lists you as recusing, so.
Yep,
keep it
both
that way.
correct.
Thanks.
Okay, we will now move to docket number 24 SPEE 540 TAR. This is a proposed order on settlement agreement. Our presenter for this item is Mr. Aaron Bailey.
Hey, good morning, Commissioners. This is Southern Pioneer's application to approve a renewable energy program rider tariff through a unanimous settlement agreement that was filed by the parties. So just a little bit of background on this one. Back in January, Southern Pioneer requested approval of its renewable energy tariff for voluntary participating customers, essentially allowing commercial or residential customers to participate in renewable energy options without, having to build on their property. So, and just as a way of background, which is outlined in the draft order, Southern Pioneer is a subsidiary of Pioneer Electric Co-op, has about 17,000 customers in Barker, Clark, Comanche, Haskell, Kingman, Kiowa, Meade, Platte, Reno, and Seward counties, which is all listed in the order. So essentially, they're proposing a two-tiered program, one for commercial, one for residential customers. The draft order outlines the different options that each customer would be able to voluntarily enter into, as well as Southern Pioneer's draft participation agreements, which will all be incorporated in the order and is outlined in paragraphs 6 through 10 of the draft order. We did have a few interveners in this one. We had Curb, National Beef Packing Company, and Air Products Chemicals, Inc. So in May of this year, staff recommended approval of the program and the proposed agreements with its customers subject to the three conditions, which are outlined on paragraph 13 of the draft order. So we are recommending approval of the settlement agreement, and the three conditions that staff recommended were agreed to by Southern Pioneer. And essentially, it's just basically a way to flow through some legal fees just in case things need to be passed on. That if they collect a settlement, those will be allocated appropriately. But those are all listed in paragraph 13. Again, Southern Pioneer approved. And Curb also agreed to those stipulations. The other two interveners did not reply at all. So that's why we are considering this under this pertinent statute as a unanimous settlement agreement, because they did not object in any way. So we essentially looked at the three factors for a unanimous settlement agreement: substantial competent evidence, does it establish just and reasonable rates, and is it in the public interest? And we did outline in the order Curb, staff, their report and recommendation, as well as Southern Pioneer's testimony does support those findings. So we are recommending approval of that settlement agreement, which would be also incorporated in the order, as well as the participation agreements. So with that, I'll take any questions.
All right, thank you, Aaron. Are there any questions on this item, beginning with Commissioner Keither
No.
and Commissioner Keen?
No questions. I would move approval of the order.
Second.
All right, we have a motion and a second to approve the proposed order as described in this docket. Is there any further discussion on that motion? Hearing none, all in favor, please vote aye.
Aye.
Aye. Any opposed, say no. The order is approved. Thank you, Aaron.
Thank you.
We now move to our last noticed item. This is in docket number 24 DPAX 895 PEN, and this is a proposed penalty order in that docket. Our presenter for this item is Mr. Hassan Latif. Good morning, Hassan.
Good morning, commissioners. Can you hear me?
Yes,
Okay.
we hear you.
Great. This penalty order assesses a fine of $47,000 to Kansas Gas Service, a natural gas public utility, for violations of the Kansas Underground Utility Damage Prevention Act, the CUDPA Act, as well as federal pipeline safety regulations that are adopted by Kansas. This order is included as a noticed item because of the size of the penalty being assessed. The penalty order compiles multiple violations, alleging that on dates between January and December of 2023, there were at least 47 instances where the company failed to provide or improperly provided excavators with the location of buried facilities before excavation began, resulting in damages to gas lines. The order assesses a penalty of $1,000 for each violation, totaling $47,000. According to staff's R&R, there have been 256 notices of probable noncompliance issued to KGS between 2018 and 2022, so the dates before this year that we're currently penalizing. And that resulted in $247,000 in total penalties over that 5-year period. In the present order, The 47 alleged violations resulted in damage to natural gas lines, and KGS responded to each of staff regarding each of these violations, stating it did not oppose staff's findings. Staff believes the order appropriately assesses penalties against the company and recommends approval of the order. I and staff are available to answer any questions you have.
All right, thank you, Hassan. Commissioners, are there any questions on this item, beginning with Commissioner Keither
No.
and Commissioner Keen?
No questions. I would move approval of the order.
Second.
Got a motion and a second to approve the order as described in this docket. Is there any further discussion of that motion? Hearing none, all in favor, please vote aye.
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 Aye. Any opposed, say no. The order is approved. Thank you, Hassan.
Thank you.
With that, we have come to the conclusion of all the items noticed on today's business meeting agenda. If there's nothing further to come before us this morning, I would entertain a motion to adjourn.
I move that we adjourn.
Second.
Got a motion and a second to adjourn. All in favor, please vote aye.
Aye.
Aye. Any opposed, say no. We are adjourned.